process point, it was mentioned yesterday that there is a Purdue Pharma hearing this morning, and we had delayed the start until this time to allow as much time as possible for that hearing to conclude. We understand it is still going, but we are, we've discussed with those who are involved there, and they're okay with our procedure. Mr. Price for the OCC is still in that Purdue hearing, and as well as a few others. And so they won't be here right now. Hopefully, we'll be joined by the end of the hearing. But we'll try to push off any statements and the like until we know that Mr. Price is present and can present his statement.
All right.
All right. With that, let's dive right into the objections where we left off yesterday. And the first one in the chart is the Securities and Exchange Commission. The objection was filed at docket 2401, and I'll yield the podium to the objector.
Thank you, Your Honor. This is Alan Meza from the SEC. Could you hear me?
I kind of trying to find, there you are. Okay, go ahead, Mr. Meza.
Thank you. Your Honor, the issue that we're raising has been raised before Your Honor and many other courts by the SEC, probably as well as the U.S. Trustee's Office, regarding the opt-out mechanism that's being utilized. And we have a particular concern here with regard to shareholders and 510B claimants who are deemed to reject the plan. I've argued this issue before numerous courts, and the consensus, I would say, with regard to at least the deemed to reject class, which is not receiving any consideration under a plan, is that the opt-out is just not an appropriate mechanism. And I know one of my colleagues argued this matter before Your Honor in AAC Holdings, and I cited that in our objection, where Your Honor asked the obvious question: so what reasonable investor who's receiving absolutely zero under this plan is then going to opt say, you know what, take away my releases as well? It doesn't make sense under published decisions such as Emerge and Washington Mutual. And it's, from a logical perspective, it makes absolutely no sense. And this is even in front of other court, Judge Gross, we've had this issue. He has agreed, and even judges in other districts, I've had this matter, like in Windstream in front of Judge Drain, who is always in favor of an opt-out, but he too draws the line at a circumstance where the stakeholders are getting nothing under the plan. He says there's absolutely no basis to put the burden on the stakeholder who's receiving no consideration, especially for third-party release, which obviously is supposed to be under Continental, the rare situation. And this is just basically the debtors taking an opportunity to take advantage of those inattentive shareholders who may not read the plan. It's going through third-party intermediaries, so they may not even get it. And it's just, it really is not justified. We try to resolve this issue. We're not making an issue with the opt-out, even though we typically would object to an opt-out by even creditors, but we understand that there's stakeholders in the creditor class that are very active in the plan process. They're entitled to vote. So we're not raising that issue here. However, for the shareholders and subordinate claimants, I don't think there's any basis, and the debtors will not be able to find a published decision to support their, to advance this process. So we're raising it at the disclosure statement hearing because they have sought to approve this as part of the solicitation process. We think it, as Your Honor recommended in AAC Holding, or we suggested, it could be addressed at this point, and this issue could be taken off the table today and not be reserved for confirmation battle on this obvious issue.
Mr. Gott?
Yeah, Your Honor, I think we are all in agreement that the issue fundamentally goes to confirmation of the plan. Recognizing that, yes, today we have an opportunity to address it, but at bottom, I think the point here is that the debtors recognize that the structure as it currently exists is being challenged. We've added disclosures to that effect in the disclosure statement. And we think that is the proper resolution for today. We understand the risk heading into confirmation. I think despite Mr. Mesa's statements, we would all recognize that that the decisions, reported or not, are a mixed bag, and there are plenty of cases in this court, in the district, that support the notion that even for deemed to reject classes, an opt-out structure is appropriate and can be utilized, and frankly is consistent with class action practice in Article 3 courts. So all to say, Your Honor, we don't think there is such a fundamental issue that would preclude issuance of the disclosure statement. We don't think this rises to the level of the standard for today, which is patent unconfirmability. We have legal support for the position that we are taking and for the structure of the plan, and so we think the objection should be overruled.
Well, are classes that are deemed to reject because they're doing nothing under the plan, are they going to be solicited?
They will get notices. So equity holders will be sent notices, as Mr. Mesa suggested, that maybe through intermediaries. There will also be publication notice, which is, again, sufficient due process for those unknown stakeholders from a constitutional perspective. And those notices will put them on alert to the existence of the releases. And so yes, I think the answer is yes. They will receive notices. They will be on notice that is adequate from a constitutional perspective of the plan and the proposed releases.
Well, they're going to be given the opportunity to opt out, or is it they have to object to the plan?
No, there will be, so for subordinated claims, I guess, well, to clarify one thing in the first instance, we don't intend to parse the claims register at this point to move claimants from to take proofs of claim and put them in the subordinated claims class, and therefore not send them a solicitation package. Anyone with a filed proof of claim, I think, will fundamentally be receiving a solicitation package. So that will have the opt-out option in the ballot there, and then the notices that will go out to the deemed to reject class will indicate that they are able to obtain an opt-out form and to submit that in lieu of having to file an objection. So and if there's any lack of clarity on that front, we'll look at the documents again just to make sure that that's crystal clear. But the intention is for the opt-out to be able to be done through a simpler election and not filing not having to file an objection to opt-out.
Well, that is a concern of mine, that I want to make sure that people who are deemed to reject are going to have an opportunity and make it crystal clear that they have an opportunity to submit a form to opt out of the third-party releases.
Understood, Your Honor. We may even be able to develop a streamlined process for doing so, although it may take a little while in discussion with our noticing agent, but we will make it clear that opt-out forms are available, simple forms, and can be obtained by contacting the noticing agent or visiting the case website, for example, all of which should really streamline that process.
All right. Well, I do think, I don't want to prejudge the issue at this point. I do think it is a confirmation issue, but it is one that I am interested in. And I think it does depend on the facts and circumstances and how the noticing is done and whether or not I believe at the end of the day, parties had a full and fair opportunity to receive and understand this opt-out and be able to obtain the proper form to be able to submit that opt-out. So, but we'll deal with that at confirmation.
Okay, thank you, Your Honor.
Your Honor, may I just address one more point? I realize we're reserving this for confirmation. I just, in terms of, at least in emerge, it was an unconfirmable matter. So I'm wondering if Your Honor would reconsider with respect to, because the court was, Judge Owens was reluctant to confirm the plan at confirmation based on that. She denied confirmation based on this issue. So I'm wondering if that changes Your Honor's perspective, at least deeming it patently unconfirmable at this point.
No, I'm aware of Judge Owens' decision in emerge. At this point, my view is, that, as I said, this all depends on the facts and circumstances and how this is played out in the solicitation process. So I'm not going to rule at this point that the plan is patently unconfirmable because it contains releases of third parties through this opt-out system.
Okay. One last question, Your Honor. Are we able to rely on this submission as our objection to confirmation?
Mr. Gott, do you have any objection to that?
No objection. That's fine for the debtors.
Okay, so
that's fine, Mr. Mosley.
Okay, thank you. So just to be clear, this will be our confirmation objection. We will not, unless we file supplement, this we will stand on these submission. You, sir.
Your Honor, sorry to interrupt. Michael Joyce for the Canadian Elevator Industry Pension Fund. Your Honor, we have a similar objection to the third-party releases and the solicitation aspect of those releases. I don't want to go out of order, Your Honor, but I thought it might be appropriate time to be heard.
Well, Mr. Joyce, first of all, you're sitting sideways on my screen.
I have a bit of a Zoom setup here, Your Honor, that's not my typical one.
Well, is your objection the same, these third-party releases?
We have objected to the substance of the third-party releases. Your Honor, we would reserve those objections for confirmation. But we also have joined in the U.S. trustees objection, Your Honor. We have an objection to the solicitation aspect of the notices and the third-party releases.
Well, I think I've already ruled on that, so I don't think there's any need for further argument at this point.
Very well, Your Honor. Thank you.
Thank you.
Next, Your Honor, we have the next unresolved objection, anyway, is filed by the City of Marietta. We were able to resolve some points here and not others, and so I'll turn the podium over to Counsel to Marietta.
Right.
Good afternoon, Your Honor. Michael Etkin, can you hear me?
I can, thank you.
Thank you. Your Honor, we filed a joinder to the disclosure statement objections of the ad hoc group of ACFAR claimants, the Attestor and Humana claimants, as well as the Unsecured Creditors Committee. We have worked with Debtors Counsel, as Mr. Gott has indicated, and we've resolved most of the issues that we've raised, and we paid attention to the hearing yesterday where several other issues were raised by those objectors. So there really is only one remaining concern that we have and wanted to raise today when we had the opportunity. We don't know what the resolution with the Creditors Committee is and what changes are going to be made as a result of that resolution. Again, that was an objection that we joined in. So that'll obviously be relevant, or we believe it'll be relevant to us as well. But the one remaining concern is the fact that the disclosure statement and the plan itself expressly state that the debtors are not being substantively consolidated pursuant to the plan. Yet it's equally clear that at least for purposes of distribution to unsecured creditors, the debtors are being consolidated for distribution purposes, irrespective of where a particular unsecured creditor's claim sits. Creditors, therefore, in our view, and we've raised this with the debtor and have had discussions with the debtor on this point, they need to compare the results stemming from the consolidation for distribution purposes in terms of their treatment with what recoveries they might obtain if the treatment and distribution was on a debtor by debtor basis. So we've asked for that information to be included in the disclosure statement because we believe that creditors cannot really make an informed decision in connection with their treatment and that being distribution on a consolidated basis without getting a sense of what distributions would be like if distribution was on a debtor by debtor basis. So everyone essentially conceded yesterday that the ability of a particular creditor to make an informed choice in connection with voting for or against the plan, we think, and we've urged the debtor in our discussions, that it would be critical as to what needs to be included in the disclosure statement relating to the issue of the distinction between distributions on a debtor by debtor basis and distributions effectively on a substantively consolidated basis for distribution purposes. In other words, what would distributions to unsecured creditors look like without this de facto substantive consolidation for distribution purposes? So we've urged the debtor that creditors should and are entitled to that information, and that should be included in the disclosure statement. I think that there may have been variations to that theme that were raised by other objectors yesterday, but that's really the one issue we wanted to bring to the court's attention. We think that for disclosure purposes, everything else has pretty much been resolved.
Thank you, Mr. Ecken. Mr. Scott?
Your Honor, I think three points in response. One is, I think what's being requested goes directly to the Section 1125 non-requirement for a disclosure statement in that the disclosure statement does not have to describe results or describe what alternative plans might have looked like beyond the plan that is actually being proposed. And fundamentally, that's what council is proposing here, is for us to calculate what distributions might have looked like under some alternative plan. And that bridges to the second point, which I think helps understand the rationale for that statutory rule, which is we don't know what an alternative plan might look like. We don't know. For us to postulate what distributions might look like under some alternative plan would require us to consider an infinite world of possibilities and other things that may have to take shape if we were to make distributions in a different way. That may change other aspects of the plan, and then all of a sudden you're in a world where terms start moving around, economics start moving around. And you're really just disclosing information that ends up being useless at the end of the day. And then the third point, Your Honor, is that we have in fact disclosed, as we discussed yesterday, what the debtors believe are the waterfall entitlements of general unsecured creditors, and put that into the disclosure statement, which essentially answers the concern that Marietta is raising here, in that it informs creditors that, you know, if we were to revisit the distributions, that would be the baseline, and you'd work up from there. You'd have to work up from there to get to the $100 million. So, you know, that's the debtor's view on what the baseline would be, and any step further to try to take what is proposed in the plan, which is substantially more than $34 million. It just addresses hypothetical plans that aren't at issue today, and so those disclosures aren't required under Section 1125.
Was there any disclosure in the disclosure statement that if distributions were made on an other than a consolidated basis, that there could be material differences in the distributions to the classes as what is being proposed in this plan?
Well, I don't know that we specifically say that. Again, it would be. I suppose that is a truth that we could put into the disclosure statement. We would agree with that statement, that if we made distributions in different ways and in some other way, those distributions could look very different. You know, we have included with the disclosure statement our liquidation analysis, which is done on an entity by entity basis and not a consolidated basis. So, frankly, creditors could go to that document to get a flavor of what their entitlements might be. Obviously, a scenario would look a little different from a plan of reorganization from a total value perspective, but that is a way for a creditor to get a little more information about what entity by entity distributions might look like. But Your Honor, I think beyond simply stating the reality that if distributions were done differently, then the results could be different. It would require us to make alternative assumptions about alternative realities that just aren't an issue with this plan.
Well, I agree with you. I don't think we need to include in the disclosure statement what the distributions would be under alternative plans, assuming there was no substantive consolidation for distribution purposes. But I think there needs to be something in there that says that there could be a material difference for distributions if it was not done on a consolidated basis, and maybe refer to the liquidation analysis and say, you know, as an example, look at the liquidation analysis and you can see what you would receive on an entity by entity basis in a liquidation scenario. So I think that's what Mr. Etkin's concern is, that a reasonable investor or creditor might look at the plan and not understand that there could be a difference if they receive the distribution on an entity by entity basis. And I think that's all that needs to be included. We don't need to do a full analysis of what that distribution would look like. We just need to let them know there is a potential for a difference if you vote for this plan.
Sure, Your Honor.
Your Honor, may I be heard for a moment?
Who's speaking?
It's Michael Etkin, Your Honor. May I be heard for a moment?
Go ahead, Mr. Etkin.
Thank you.
Go ahead.
I think Your Honor, you hit the nail on the head in terms of the overarching concern. This is not a matter of laying out a grab bag of plan options. The debtor has said they're not substantively consolidating these cases, but they are substantively consolidating the debtors for distribution purposes. So that's what really raises the issue. And it's not a question of just saying in a general sense, well, if we put a different plan out there, the treatment would be different. That's obvious and a bit simplistic. I have a concern about focusing directly on the liquidation analysis, because that may be done on a debtor by debtor basis, but it's also in the context of a liquidation of these estates as opposed to a restructuring. I think that I'm certainly prepared to try to work on the language that the court has suggested with Mr. Gott, and I understand, the court's reaction and decision with respect to taking a deeper dive with respect to that. But I do think that something needs to be said if the debtors are contemplating treatment, that if it doesn't work, or if there was an alternative on a debtor by debtor basis, that it would result in a different set of results. So,
Your Honor, if I may.
As I said, I don't think this doesn't need to be overly complicated. I think it only needs, and it's going to depend. I mean, it could be depending on, which entity the creditor has a claim against. If it was done on a non-consolidated basis, they might get more, they might get less, might get the same. We don't know. And I don't think the debtors need to go into detail on which entity would receive more, which would receive less, which would receive the same. I think there just needs to be, and so that creditors understand when voting on this plan that it's being done on a consolidated basis. Distributions are on a consolidated basis. And if it was done on a non-consolidated basis, their recovery could be different, either greater or lesser.
Your Honor, just to address one point about the plan, which I think may explain some of the disconnect here. So while the distributions for general unsecured creditors will be generally done on a consolidated basis under the plan, we have expressly provided and reserved that to the extent necessary to satisfy confirmation requirements, whether those are best interest requirements or unfair discrimination requirements, whatever they may be, that would dictate a different result than what would result from a true pure consolidation, that we are reserving the right to make non-ratable distributions to account for those requirements. And I think that's why I had a little bit of trouble understanding what would be accomplished by showing that there, or saying that there may be different entitlements, because we fundamentally are going to honor any entitlements that we are required to honor under the bankruptcy code. But if Your Honor's directive is to include a disclosure that in a non-consolidated scenario, distributions could look quite different from those that would be done in our distribution consolidation, we can certainly tackle that.
That's all I'm looking for, and I think this is a sentence or two. That's it. I mean, it's not overly complicated.
Okay, we will do that, Your Honor. Thank you.
Thank you, Your Honor.
Thank you, Mr. Edkin. Once you're done speaking, for some reason today on my Zoom, I cannot lower people's hands. So once you're done speaking, if you could lower your hand, that would be helpful. Then others, when they raise their hand, I can see them more clearly. Okay, go ahead, Mr. Gott. What's next?
Next, Your Honor, is the objection of U.S. Bank National Association, original objection at docket 2407, supplemental objection at docket 2856. So I'll turn the podium over to counsel for U.S. Bank.
Good afternoon, Your Honor. John Ashmead for U.S. Bank, who's indenture trustee for the MIFs and Ludlow notes and debentures. We joined in the UCC response, and UCC counsel will be speaking, I presume, shortly, so we'll sort of leave that to keep it short. Your Honor, in terms of the disclosure we were looking for, it largely mirrored what Mr. Etkin just discussed, so I'm not going to go over that. And I will also add that Mr. Gott, some of his colleagues, reached out to me yesterday and today to work on some additional language, and I'm sure we'll work that part of it out. And if they add the stuff that Mr. Etkin talked about, that will help as well. I think the only thing I'd mention that was in our responses, Your Honor, that won't, or maybe won't be covered by the UCC counsel was, we do still think it is premature in light of the mediation, and we should just sort of see where that turns out so we don't have to do a redo. I'm not going to belabor it, Your Honor. You've heard that from a number of parties. And lastly, and again, you heard a little bit of this, I think, from Mr. Feldman yesterday, and I assume you might hear it from UCC counsel, is just the notion about, this case is a bit of a, square peg in a round hole in the sense that, there was a deal negotiated on the specialty generic side that contemplated just that side being restructured. Then the CMS judgment came out and a couple of other things, and they decided to do everything, but they never changed that. And it sort of makes it difficult. And I only raised that point as others did, I think, is, not wanting to be wasteful and going down a path that may result in a redo, particularly in light of the mediation, which has already commenced. And with that, Your Honor, I have no further comments.
Thank you, Mr. Ashmead. Well, we might as well address this issue of postponing this pending mediation. I'm not going to do that. I think that the parties here are all highly sophisticated, well represented, and can certainly tackle both the mediation and the plan confirmation process going forward. And there's the risk that it could result in additional time having to be incurred if the mediation turns out differently than the parties are anticipating at this point. But it also saves time if the mediation turns out appropriately and the plan can move forward. So either way, there's a potential for a delay that would increase the costs to the estate. And I'm mindful of the fact that, at this point, we're at $20 million a month on attorney's fees in this case at this point. So we need to move it forward as expeditiously as possible. And I think whether I delay it now or delay it later, if things don't work out, it's 6 of one, half dozen of another. So at this point, I'm going to allow the process to proceed. Okay.
All right, Your Honor.
Mr. Gott.
Thank you.
Next objection we have that is unresolved was filed by the United States trustee at docket 2414.
Okay, I had third-party payers next on my list. Did that get resolved?
It was, Your Honor. I mentioned in my opening remarks yesterday that we resolved it between the time that the chart was filed and the start of the hearing. We'll have actually a couple more of those as we go through here. I'll make sure to, next time I'll pause and let you know. But yes, we did resolve the third-party payors objection.
Okay, thank you. Ms. Leamy?
Good afternoon, Your Honor. Jane Lamy for the U.S. trustee. Our remaining objection concerns the third-party release and opt-out, and it was covered by the SEC. We also expanded our objection to include abstaining creditors, non-opioid creditors who abstain from voting and rejecting creditors. But I heard you loud and clear that that's a confirmation issue, so I'll defer argument on that until confirmation. Would like to request, though, at this time that the debtors consider a carve-out from the definition of non-debtor releasing parties for any party in a voting class whose solicitation package is returned as undeliverable, and that they'd be listed in the balloting or voting report. If parties don't have knowledge, they can't really be deemed to consent to a release. So we would request that the debtors clarify that the voting tabulation report will list those parties who, 1, opt out of the releases, 2, whose solicitation package is returned, 3, or are in voting classes that did not receive a package. Because I believe their order right now provides they are not required to serve anyone who's was previously returned as undeliverable, which would make sense. And that way, Your Honor, there will be a court record as to these parties that can be reviewed at the time of the confirmation hearing. Thank you.
Ms. Scott?
Your Honor, if I'm understanding the request correctly, I think that makes sense. And my understanding of Ms. Leamy's point is that we keep record and keep the information for those parties whose mail has previously been returned as undeliverable or whose solicitation packages are returned as undeliverable, and make sure that information is disclosed. I think we'll, of course, as to individual creditors, that information may need to be sealed, may need to be protected in some ways, but we can certainly keep that information, keep it handy, and then tackle the issue, the confirmation issue of whether those parties should be bound by the release at the confirmation hearing.
Ms. Leamy, is that what you were looking for?
Yes, thank you, Your Honor.
Okay, thank you. All right. Excellent. Mr. Gott, what's next?
So moving down the list, so the next place we have in the chart that is unresolved is the West Virginia NAS claimants and adult claimants. This objection has been resolved though, and was withdrawn yesterday with a filing on the docket. Next objection was filed by Daryl Edelman, a shareholder. Your Honor, so I received an email this morning from Mr. Edelman, and I'll read the email and then get to the point. His email said, I was available yesterday to speak to my objections to the disclosure statement, but will not be available today. As a result of this, I ask that you enter this document into the record during this hearing when you get to my objections. Thanks, Daryl Edelman. And he sent a 3 or 4 page statement regarding his objections that, frankly, Your Honor, I'm a little bit disinclined to read a statement against my client's interests into the record on behalf of a party who was unable to attend to press their objection. So we think it would be appropriate to overrule the objection and move forward. But if Your Honor would prefer I read the statement, I can do so.
Well, I'm looking at what his original objections were here. Let me take a look at these real quick.
Sure. And I'm happy to lay a little argument, lay some groundwork for that if you'd like, Your Honor.
Court, hear me. This is Daryl Edelman. I actually was able to.
Oh, great.
Oh, Mr. Edelman is here. Okay. Well, let me hear from Mr. Edelman then. Go ahead, Mr. Edelman.
Thanks. Thank Your Honor for allowing me the opportunity to speak to my objections as outlined in my submission in document 2421. I understand it's not a popular position to argue against the opioid claimants, and the immediate response to this is to classify objections as a way to blame the victims.
Mr. Edelman, you're fading out. Can you get closer to your microphone and speak up?
Is that any better?
Slightly.
Yeah, I'm not computer literate that much, so I'll try as best I can. My primary objections that I had to disclosure statement was that it was premature, and the reason that I said that was I have been trying to follow the manner in which the opioid claimants or the claims have been made, and whether they have filed claims and proof of claims. And I cannot find that, and I cannot find any information that has been provided that says when they will file those claims. From a shareholder perspective, we have very few rights in these bankruptcy cases, other than to say that we have the right to be heard. So it doesn't mean that we do have a right to challenge claims when the proof of claims are submitted. And unfortunately, because that hasn't been done, I personally don't really know what to do. So, I do understand that there has been, I think, 370 pages of claims that were listed, 2,868 in the original assets and liability document that was been submitted, but I don't know where these claims fall in terms of how one evaluates whether they are. I do know that the court has the ability to transfer all the opioid claims litigation to the district court for resolution, and that is one thing that I would like the court to consider. Especially when it's important for those who will see no recovery. I think from my perspective, I just want to make sure that I am heard, that the opioid claims are deemed to be legally enforceable against the debtor, and that's what sort of proves that they have a right to the claims. So with that, that's basically my objection in a nutshell in this one. Thanks.
Mr. Scott?
Your Honor, we certainly we hear the concerns and understand the argument, which is that from a shareholder's perspective, and we've heard it before in these cases. From a shareholder's perspective, that if one were to conclude that the opioid claimants are not entitled to anything, then there may be something more there for shareholders. As we've discussed previously, we don't think that proposition reflects the reality of the situation. And Your Honor has previously ruled that shareholders are indeed out of the money in this situation for that very reason. And so at bottom, I think the concerns being raised are confirmation issues and our challenges to the plan and the propriety of the plan. So we think they should be overruled for today's purposes.
You want to address Mr. Edelman's concern about the lack of proofs of claims filed by opioid claimants and why that is so, just so he understands it?
Sure, happy to do that. Well, first, there are, I think there have been a couple hundred opioid claims that have been filed, but earlier in the cases, we made the determination not to have a claims bar date for opioid claims, and that is part and parcel of the overall resolution for opioid claims embodied in the plan, in that those claims will become assertable only against the opioid trust after the plan is implemented. And at that point, the trust will go through the exercise, or various trusts will go through the exercise of bringing in claims, sending out notices, asking anyone who wants to file a claim to submit it. And then those trusts will be responsible for administering and resolving those claims. But because that process is one that can take place entirely after confirmation and not slow down our Chapter 11 process and keep us in the case any longer, we made the determination that bringing those claims in during the case was not necessary, and instead they'd all be transferred to the opioid trusts.
Thank you. Mr. Edelman, does that address your question about why there's no opioid proofs of claim filed?
Well, to some degree. It seems to me that that's more convenient for the debtor than for anybody else, because once the plan is confirmed and it goes to the opioid trust, there's no way for shareholders to challenge any of those claims.
Well, Mr. Edelman, I think at this point, what the issues that you are raising go to confirmation of the plan rather than to the disclosure statement. At this point, the only thing before me is whether or not to approve the disclosure statement that the debtors are proposing to submit to the creditors of the company, so that they can vote on whether or not to approve the plan or disapprove the plan. And the issues that you're raising are whether or not the plan itself should be confirmed once we get to a confirmation hearing. That's not going to happen until September. So those are issues that are preserved for you at this point, and we will have to deal with them in September when we get to confirmation.
Thank you.
All right. Thank you, Mr. Edelman. Ms. Scott,
Your Honor,
go ahead.
Yeah, Your Honor, the next objection we would come to is on the list is Teva Pharmaceuticals. We had a reservation of rights filed by the State Teachers Retirement System of Ohio, which is been duly docketed, and I'm not sure we need to stop and pause on that. But the next place we would go is Teva Pharmaceuticals, and actually I was informed by counsel yesterday that Teva, and then the objections filed by Johnson & Johnson, and then the distributors, manufacturers, and pharmacies group, which are the 3 out of the next 4 objections on our chart, will all be taken up, largely be taken up together by counsel for one of the distributors. So I think we'll turn to those issues now, and I'll cede the podium.
All right. Who's
Yes.
Mr. Goldstein? You're muted, Mr. Goldstein.
Apologies for that. Michael Goldstein, Goodwin Proctor, for Teva. Just for the record, Your Honor, confirm Mr. Garfield on behalf of McKesson is going to speak for the distributors, manufacturers, and pharmacies for efficiency purposes and avoid duplication. I might take the privilege of just reserving the opportunity to comment if I think Mr. Garfinkel missed something or to elaborate, but I anticipate that won't be necessary, but just wanted to state my appearance and state that for the record. Thank you, Your Honor.
Thank you, Ms. Goldstein. Mr. Garfield?
Mr. Garfinkel, Your Honor. Jeff
Garfinkel,
Garfinkel, Buckhalter on behalf of McKesson Corporation and certain of its corporate affiliates. We are part of the collective group of distributors, manufacturers, and pharmacies for purposes of the argument. I'm just going to call them the debtor's customers. So this is our first opportunity to come before Your Honor. I appreciate that I speak for McKesson, but there are similarly situated companies, all who have separate counsel. We thought it better to do a collective objection as we did in Purdue, and we were complimented for self-organizing to make it easier for the debtor and the court to address these objections rather than do them individually. The primary, and the debtor acknowledged this in their customer motion, there is a critical nature of the customers for the success of the business. For the distributors, all of us have contracts in which there are indemnity and insurance obligations for which we distribute at the distributor level all 25 of the debtor's generic products and certain of their branded pharmaceuticals for which they have 5 primary. All of the defendants, all of the parties in my group, there were 8 that filed the objection, 9 that filed the supplement. All of us are co-defendants with the debtor in massive amounts of state court and federal court lawsuits in all 50 states, the District of Columbia, the Commonwealth of Puerto Rico, certain provinces in Canada, and in tribal courts. All of us would be co-defendants with Mallinckrodt in those lawsuits, but for the debtor's filing of bankruptcy in the automatic stay. As we point out in our initial objection, and we emphasized again in our supplemental objection, there is a serious issue on what we have termed defensive rights. That is the rights of co-defendants to list the debtor as a co-responsible party or single responsible party for any liability that may be imposed. And the problem with the plan in that it purports initially to deprive the co-defendants of their right to not seek liability against the estates, but rather simply name the debtor as a responsible party on jury verdict forms and otherwise liability apportionment. Again, that would have no impact whatsoever on the estate. This issue arose in the Purdue Pharma case, a case which the debtor is relying heavily. In fact, their plan has 7 references to the Purdue Pharma bankruptcy case, and we've heard a number of cross-references over the last 2 days regarding that process. We were able to reach agreement on a carve-out of the defensive rights from the releases, discharge injunctions, exculpation provisions in the Purdue plan, and we provided that language customized to this case to the Latham team. And as of last night, they are willing to include that language with one exception into the plan. And that exception raises a facially unconfirmable plan issue and a very serious issue for us. And specifically, the co-defendant rights as they, or let me go to the exact language here from the version that not yet filed with the court, but which was provided last night to my group, was the plan now has a new defined term, co-defendant rights, that reads and prohibits, and I'm going to quote the clause that is really of concern, shall in no case result in the debtors or reorganized debtors as opposed from the opioid MDT2 being named on a jury verdict form or other finding of liability. So the plan, as the debtor proposes, would prohibit mallinckrodt or reorganized mallinckrodt from being named on a jury verdict form. Now, why does that matter? And I'll put this in concrete terms. Today and next week, there are 3 ongoing trials in the United States on opiates. One is in California, in Orange County, California, in which certain of the manufacturers of opiates are defendants. But for the debtor's bankruptcy case, mallinckrodt would have been a defendant in that. Today, in a federal court in West Virginia, there is an opiate trial going on involving the distributors. Next week, in Suffolk County, New York, in state court, there is going to trial another opiate lawsuit in which both manufacturers, pharmacies, and distributors are co-defendants. But for mallinckrodt being in bankruptcy, it would be a party to that lawsuit. As we sit here today, if this were going to a jury verdict, the defendants that remain in that could name Purdue, Insys, another opiate manufacturer which is in bankruptcy in this court, and mallinckrodt as responsible parties in terms of any liability allocation. Yet on plan confirmation, the co-defendants are prohibited from naming mallinckrodt as a responsible party, which makes absolutely no sense in our view, and a restriction that doesn't exist as to Purdue and Insys. We think this is a facially unconfirmable plan issue. If the court wants to reserve it for plan confirmation, so be it. But we can't be put in a position where today, tomorrow, and next week, we can mention Purdue as being, mallinckrodt being a responsible party during the course of the trial, put them on a jury verdict form, and come September, maybe one of the jury's out in the state of New York in the Suffolk County trial. They need to be removed from the jury verdict form because of this provision in the plan. We've tried to explain this to the other side. It is a serious issue for us. And I just don't want the court to be aware of this. If the court wants to defer this to plan confirmation, so be it. We think this is a gatekeeping legal issue which prohibits confirmation or approval of disclosure statement at this time. We have a couple of other minor issues that we can raise, but this is the most serious disclosure statement plan issue for the group for which I am speaking. There are jurisdictional issues that certain of the parties have raised. I think Teva and Johnson & Johnson have raised the jurisdictional issue on this point, but I'm going to set that aside. It's just, it doesn't make any sense that today we can name Purdue, mallinckrodt, and Insys as co-responsible parties, yet on confirmation, we can't do that.
Mr. Gott?
Sure, Your Honor. I think the argument we just heard glosses over a couple things that are important to understand. First is that the structure of the plan, what the plan says is that as of the effective date, all of the debtor's obligations as to opioid claims and all opioid claimants' rights as against the debtors, including opioid co-defendants, will all transfer over to the opioid trust. They're all being assumed by the opioid trust And what we've proposed and what our position is that the opioid trust would be the appropriate party to name on a jury form, because that is the entity that carries the liability going forward. We don't think that any of the plan provisions, and we would agree that as of today, there is no gag order or anything that would prevent the making of arguments in their defense as to Mallinckrodt's conduct, and that wouldn't be the case after the effective date either. We do think, I would take issue with one point. We do think that the automatic stay in place today would prevent the co-defendants from naming Mallinckrodt on a jury verdict form and advancing frankly on behalf of a plaintiff. The notion that Mallinckrodt carries a liability in the opioid trials, and there was litigation over this matter in Purdue, and there's been no request to lift the stay brought in our case here. So we aren't. I think that's a separate issue. Set that to the side. But I think the distinction between today versus post-effective date is a bit misleading in that respect. But the overarching issue here is that the rubber really meets the road from the debtor's perspective and the future perspective of the reorganized debtors when it comes time for the actual apportionment of fault at the end of a trial, and leaving the reorganized debtors exposed to being tagged publicly, having that liability assessed to them, and not just assessed to them, but assessed to them without the ability to or without appearing in any of those trials. What we're looking to avoid is exactly that drag on the reorganized company. That's exactly what the opioid settlement as a whole is meant to tackle. And frankly, that the level that the potential risks and consequences of those results really could jeopardize the company's ability to meet its settlement obligations going into the future if that were to become a real drag on performance. So all to say, Your Honor, we think those facts do merit the prohibition through our channeling injunction of naming the debtors, the reorganized debtors, and again to drill down on what was glossed over, as distinct from the opioid trust. The Mallinckrodt's opioid trust could still be named on a jury apportionment form. But we think that's a defensible route. We think that's confirmable. But all to say that I could go into the substance further if Your Honor would prefer, but we think we have backup for that. We think it's appropriate in the circumstances here, and so fundamentally this is an issue for confirmation, and so we would propose that the objection be overruled for today. We have, as Mr. Garfinkel noted, we incorporated every word of what the co-defendants proposed to us, with our carve out added. Frankly, the language that was proposed to us went far beyond the simple issue of jury apportionment or putting a name on a verdict form. But we, in the interest of trying to get to a resolution, adopted that language and proposed and included our carve out. We think the plan should go out on that basis. And if the issue is brought at confirmation, we think it can be dealt with appropriately there and on full briefing and in trial.
Well, is the debtor's position that the co-defendants cannot list Mallinckrodt on the jury verdict form today for these trials that are going forward in the next few days?
Yes, Your Honor. We think the automatic stay would prevent that, or at minimum, we think it would be appropriate for a request to modify the automatic stay to allow that to happen. From our perspective, it would be no different than a plaintiff looking to pursue recoveries against, say, the debtor's insurers and needing to name the debtors in a suit in order to do that. We understand that they aren't looking to actually pursue a recovery from the debtors of the estates at this time. But the fact is that, and right, that as I think we all understand, the protections of the automatic stay are even broader than those afforded by Section 524 in the discharge and the channeling and what our channeling injunction might provide. So yes, I think that would be our expectation.
Your Honor, may I be heard?
Wait, hold on a second. How do the co-defendants, if the issue in these trials is how to allocate responsibility amongst all the opioid manufacturers, distributors, and pharmacies, how do you allocate the responsibility if you don't include the empty chairs? Can they how do they, they have to be able to refer to the empty chair and say, okay, there's these 10, this is torts 101. You got 10 defendants. One of them is missing, but the 10 defendants who are in the case want to say, well, yeah, but it was those guys' fault, or at least part of it was their fault. And you have to allocate responsibility among us all. How do they do that?
Your Honor, as I noted, I don't think we're not looking for a gag order on any arguments they might make in their defense. We aren't suggesting that they can't, they can't make arguments in trial as to the level, any level of fault or liability on Mallinckrodt's part. I think the issue, though, is that understanding that this is an impingement on what otherwise may be their background state law rights. By filing a bankruptcy petition, the automatic stay says that certain actions can't be taken, including a lot of actions that otherwise would be permitted under state law. And so our view would be that the automatic stay would prevent that.
What happened in Purdue?
Your Honor,
What Judge Drain do in Purdue?
Your Honor,
Did he lift the automatic stay? Did he lift the automatic stay to allow the naming of Purdue in those actions?
Your Honor, my understanding is, for the record, this is Jordan Weber, O'Melveny and Myers for Johnson & Johnson. We're appearing today to address the jurisdiction issue, and I think this addresses your point. Our view, and my understanding is the view of the litigators involved here, is that the automatic stay would not apply to the naming of these of the debtors as liable, as potentially liable, and we would dispute the idea that exercises control or has an effect on the property of the estate. I think that the jurisdiction issue that we're here to discuss, cuts through this issue like a laser, because the example cited by the debtors of, for example, a debtor's insurer, that is the quintessential case under controlling Third Circuit law that shows that where you have a derivative claim by an insurer that can then have an indemnification claim against the debtor's estate, that is something that is within the court's jurisdiction to enjoin. But where there's no indemnification, where there's no potential liability on the part of the debtor, which is exactly what we're talking about here, it's outside of the court's jurisdiction. And so that's why we decided to both join in the joint objection of our similarly situated parties, but also to join in the TEVA objection, because it focuses on the jurisdiction issue, which we think is an additional critical issue that has not received the attention it demands. And in fact, I don't believe it was mentioned in any of the objection charts filed by the debtor, or more importantly, did not even receive a passing mention in the debtors or any other parties' reply pleadings that we're aware of. And we think this is appropriate to address this now. Controlling Third Circuit law states that a plan is patently unconfirmable where defects cannot be overcome by creditor voting and material facts are not in dispute. And the absence of jurisdiction to approve a highly negotiated release provision, among other provisions in the plan, is a prime example of that kind of issue that needs to be addressed. So we understand that there's, you know, a general desire to put off confirmation objections to later, but this is precisely the sort of issue that leads a bankruptcy court to decline to approve a disclosure statement, and they can and do that in the rare cases in which that occurs. As Mr. Garfinkel has pointed out, it's not necessarily, and I think as we pointed out in our pleadings, it's not necessarily clear as a disclosure matter what the debtor's intent is with regard to the defensive rights of co-defendants, but I think, you know, the comments of debtors counsel here today regarding, you know, the automatic stay as applicable to the debtors today is indicative of, you know, is indicative of the fact that there may be sort of a misunderstanding here of whether or not naming the debtors would have any impact on the debtors' estates. And it cannot be the case that that the court has jurisdiction to enjoin or prevent any action that might theoretically have some sort of drag on the performance of the company. The court doesn't have jurisdiction to prevent a journalist or private research report to come out and discuss the potential liability of the debtor, and that is the same here. If this provision is intended to prevent us from asserting allocation or claim reduction or set off in litigation with plaintiff, which we think it may, and that's plainly beyond the court's jurisdiction in our view. And the jurisdiction is limited at its extreme to things that relate to the debtor, the estate, or this case. The seminal PACOR case in the Third Circuit defined the court's jurisdiction as matters that may affect the debtor, the estate, or the case. And that test has been, of course, approvingly cited in the Supreme Court. And we feel strongly that taking away our right to defend ourselves against plaintiffs does not meet that test. It simply takes value away from the co-defendants and gives it to the plaintiffs, and who certainly should not be relying on this language in connection with the solicitation of the plan. That transfer does not affect the debtor, and no one is questioning the court's ability to discharge the debtor, or even at this point, although it's reserved for confirmation, the third-party release. We think that the transfer of value does not meet even the very expansive rule set forth in PACOR, because the conceivable effect on the estate of the debtor is an expansive rule. We would also direct the court to the Third Circuit's decision in combustion engineering, which is directly on point. That, for the record, is combustion engineering 391 F3D 190 at 230. And just to conclude, Your Honor, we don't believe it's appropriate for the court to send forward a plan for solicitation that indisputably goes beyond its jurisdiction and use judicial, estate, and creditor resources on such a plan. The effect of the plan's release remains unclear, and the debtors are best to clarify.
Hold on. Debtors aren't asking me for an injunction now. What their argument is, and the reason I asked the question is I wanted to understand what their position was here. Their position is the automatic stay applies to your being able to name them on a jury form. You disagree and say the automatic stay doesn't apply. So at this point, you're free to name them on the jury form and run the risk that I find against you later on if it turns out that is a violation of the automatic stay. But that's the risk you take. And I'm not making any judgment on that this way, at this time, one way or the other. It's not before me. It's not the issue. The issue now is, as Mr. Gott laid it out for me, the plan is going to say all opioid claims are transferred or are channeled to the trust. And once the plan is confirmed, if it is confirmed, then you can name the trust as in your defensive positions in your cases. But at this point, there's, the risk is on you. If you want to name them, you can name them as going forward. But you run the risk that it turns out the automatic stay does apply. But you seem pretty confident it doesn't. So it's up to you. I'm not going to give you a comfort order on that one way or the other because it's not before me.
We agree, Your Honor. We're not here to seek any order, or we're not here to discuss the automatic stay issue. We think that was, raised in connection with, your discussion with Mr. God. The reason why I latched onto that point is because it's indicative in the jurisdiction cases in the Third Circuit. It's the same issue as to whether or not there is any impact on the estate. Right, it's a similar issue as to whether or not the automatic stay applies. We think that there is an injunction, in the plan as to that's unclear as to whether or not we can assert these defensive rights, and we think that the court does not have jurisdiction to approve that for a similar reason as we think the automatic stay does not apply, which is that it has no conceivable impact on the property of the estate. And I'm not a personal injury or the kind of litigator that deals in those cases, but my understanding is that this is the normal way to apportion, to exercise, your rights of apportionment, which is to name the party that engaged in the conduct on the verdict form. And the rules may vary from state to state, but we cannot have a plan that would eliminate that. And our view is that it's plainly outside of the court's jurisdiction and patently unconfirmable, and it should be fixed now, not later on. Thank you.
Well, it sounds like the only thing that needs to be fixed is whether or not the disclosure statement. What is this, Mr. Gott? What does the disclosure statement say now? That if the plan is confirmed, they won't be able to name the debtor as a co-defendant, but they will be able to name the trust as a co-defendant. Is my understanding correct?
Yes. Yes, as modified and as Mr. Garfinkel noted, this was this has been done over the course of the last 48 hours or so. So we haven't filed a plan with this language in it yet, but the plan as modified would say precisely that. And we added disclosures to the disclosure statement to explain that point. Those are found at Article 4Z of the disclosure statement. It says the opioid permanent channeling injunction under the plan will enjoin any party from naming the debtors or the reorganized debtors in any apportionment or allocation of liability in any litigation or proceeding insofar as the claim or cause of action asserted in such litigation or proceeding is an opioid claim.
And does it go to the next sentence to say that they are permitted to name the trust, the opioid litigation trust?
Yes. So so let me say that a little more clearly. So the revised documents as filed will say that, but the excerpt I just read was from our previously filed disclosure statement. So yes, the updated disclosure statement will include that, the next sentence to capture the same point.
All right. So Mr. Garfinkel and Mr. Weber, it sounds like they're not saying you can't name the debtors now, or you can't name, if the plan is approved, you're going to have to use the trust because all the liabilities are going to be channeled to the trust. So you're not losing any defensive rights. So what am I missing here?
Your Honor, may I address first? You asked the question as to how they deal with this in Purdue. I'm not the lead counsel for McKesson and Purdue. I'm co-counsel with the Jenner Block firm. I don't think, as I recall, and I've been fairly monitoring the filings in Purdue, that there was ever a relief from stay motion that was necessitated in this regard. I take great exception to an argument that naming a co-defendant, bankrupt co-defendant on a jury form for which no liability would come to the estate at all violates the automatic stay. There's no provision of 362 that could plausibly be read that way. No court in the history of as far as I know, there's not a reported decision ever so holding. So
I already addressed that. I already addressed that, Mr. Garfinkel. I said I'm not making any ruling one way or the other on that. You're not getting a comfort order out of me. I'm not going to make any comment on it one way or the other. You run the risk. You do what you think you have the right to do, and we'll see how it plays out.
Understood. Now let me go to the language of kind of the absurdity of this. What they're saying is we can name the trust. but can we name the trust as successor in interest to mallinckrodt? Can we say that in the jury form, opiate MDT trust, MDT2 as successor in interest to mallinckrodt? Is that prohibited? Because what we're talking about here is pre-bankruptcy conduct by the debtor in terms of presentation to a jury. And we have over 3,500 lawsuits, all being handled by state court or federal court litigators who are being asked to present cases to trials and tribunals all over the country and in Canada. And to suggest that we can't name mallinckrodt on a jury verdict form as opposed to a different name, opiate MDT2, is something that's been unprecedented in that regard. We can name Purdue, we can name Insys, but we can't name mallinckrodt. That makes no sense. And I understand the automatic stay issue and the court doesn't want to give an advisory ruling on it, but the reality is today we could do that as against the two other bankrupt opiate cases and debtors, but we can't do it as to mallinckrodt. This is a serious issue for us. I understand we can defer this to planned confirmation, which is fine, but I need to emphasize how serious this is in light of the sheer numerosity of lawsuits pending in every form in the country. So I'll leave it at that. I don't know if there's any more I can say about it.
Your Honor.
Well, Mr. Gott, hold on one second. Mr. Gott, is it the debtor's position that if this plan is confirmed, they cannot name as a co-defendant on the jury verdict form the trust as successor in interest to mallinckrodt?
So if I'm understanding the question being posed, then the answer is no. I think if it is the trust being identified on the jury form, that's what we are proposing be expressly protected within the language that will be in the revised plan. It says that the debtors or the reorganized debtors cannot be named in that form, as distinct from the opioid MDT2, which therefore could be named in that form. And we take your point, Your Honor's point, that a supplemental sentence in the disclosure statement making that point clear would be useful, and we will certainly add that.
Your Honor.
Well, I think the issue, hold on, the issue for the co-defendants is if we put MDT2 on the jury verdict form, jury's not going to know who that is. Who's MDT2? They got to be able to say MDT2 used to be mallinckrodt's. That's mallinckrodt's liabilities, but they've been channeled to this injunction. So if you find that there's liability, it's the trust that's on the line, not the mallinckrodt defendant. They can't put something on this form just says MDT2 without some explanation.
Yeah, Your Honor, that's what I thought I was addressing in responding to your question. Correct. The notion of naming opioid MDT2 as successor to mallinckrodt, that of course is accurate, and we wouldn't oppose that. That was raised in our discussions with the co-defendants, and that's right. There would be I think the notion would not be that would be prohibited. That would be permitted. And as I said, as far as during trial, during arguments, it's not our expectation that mallinckrodt's conduct can't be referenced, right? That of course is part of their right in presenting their defense. We're just suggesting that the channeling injunction under the plan can stop them from naming reorganized mallinckrodt as a liable party, and instead would permit them to name opioid MDT2, and if they want to say as successor to mallinckrodt, that's fine. I'm sure it will be very clear to any jury or any judge by the end of a months-long trial that opioid MDT2 is the successor to mallinckrodt, but that of course could be written on the form as well.
So, Your Honor,
again, I'm lost as to why this is an issue, if that's the case.
Your Honor, it was speaking for Johnson & Johnson. This is an issue because I think there's just a continued kind of disconnect here. We think it's irrelevant that the liability successor in liability would be the trust, because the purpose of the apportionment has nothing to do with liability of the trust or the debtor or the pre-petition. It's related to the pre-petition conduct. It's simply discussing what the liability of the actual defendants are. So it's plainly beyond the court's jurisdiction to approve a channeling injunction that states that we can't name whomever we want on a jury form, because that proceeding and that action has no conceivable effect on the debtor's estate. And we can't be in a position where we're constrained by language in a plan, in a channeling injunction of a plan that would prevent us from exercising properly. And as I said, the rules as to how the verdict form would work may vary from state to state. It simply would have no effect on the debtor's estate, no conceivable effect. So there's no reason why it would need to be cabined to the trust, because there's no chance of any liability flowing from these proceedings to the trust. Thank you.
Your Honor,
Well,
if I may be heard.
I just don't get what you're coming at. I mean, you can put on the jury verdict form MTD2 as successor in interest to pre-petition mallinckrodt, and during the course of the trial, you're going to refer to the conduct of mallinckrodt pre-petition, as Mr. Gott said. It's going to be very clear to everybody what the issue is. So I'm satisfied that I don't think there's any patently unconfirmable issue at this point in time. If you want to argue this at confirmation, you can, but I'm overruling the objection.
Your Honor, I tried to at least interject Michael Goldstein for Goodman Proctor. If I could just have the floor for a minute, I think I can perhaps help.
Go ahead.
Thank you, Your Honor. Your Honor, I think the problem is none of us know, and here's the disclosure issue and the legal issue, what it means to say MDT2 is successor in interest to mallinckrodt, unless we say for all purposes, including all mallinckrodt's pre-petition conduct, which will deem to be attributable to the MDT2 trust, right? That's the gap here, that we don't know if simply saying successor in interest for liability purposes under a plan of reorganization is enough for 50-state tribes, the federal court, to apportion liability for conduct. And here's the legal issue. It's not an automatic stay issue. There's a right to do this today. Forget about the automatic stay. The right exists. And I think Mr. Gott even acknowledged they are impinging on a state law right. They want to take that right away. And whether it's a jurisdictional issue or whether it's actually a best interest issue, right? Because we're not getting anything and they're taking that right away. And in a liquidation, every co-defendant would have this right. So the issue, and we can argue that at confirmation, but the point about why the proposal doesn't work is because it isn't 100% congruent with saying we're naming mallinckrodt debtor. Nobody's talking about the reorganized debtor. We're talking about the debtor's pre-petition conduct. And if there's any uncertainty that in these jury forms, by referencing some trust, even if it's a successor, without saying for all purposes, for all effects with respect to mallinckrodt's pre-petition conduct, we are opening up an uncertainty, taking away rights, and that's the problem in a nutshell. Thank you, Your Honor, for giving me the opportunity to make that point on the record.
All right. Well, that sounds like this is an issue between the co-defendants and mallinckrodt at this point. It's not a disclosure issue. That's an issue for confirmation as to what you will or will not be able to include on a jury verdict form. It's something that can be overcome by either a vote or if there are material facts at issue. What is the language going to be? What is the specific language going to be? I don't know at this point. So at this point, I'm not going to say that the plan is patently unconfirmable because of this issue. But the party should discuss this and work it out. I mean, what would you do in a case where, what if mallinckrodt sold itself before it filed for bankruptcy and now is owned by opioid distributor XYZ, and you wanted to sue opioid distributor XYZ? You'd name opioid distributor XYZ on the jury verdict form, and but you'd refer to all the conduct that mallinckrodt did before it became opioid distributor XYZ. I don't see the difference. All right, I ruled on that one. Anything else?
Yes, Your Honor. The next item, Your Honor, goes to the new definition of no opiate claims, which was added in the last.
To what? I'm sorry, yeah, Mr. Garfinkel, I lost you there for a second. It goes to what?
The no recovery opiate claims, which was a new definition added in the last, I want to say 48 hours. We had discussions, and this, I just want to confirm this on the record, with Mr. Gott on this new definition, which they are amending. To be clear, within the group that I am speaking on behalf of, some have filed opiate claims, some have not filed opiate claims. McKesson has, others have not. And the way the language was previously read, you would fall into that class if your claim was subject to disallowance under section 502E1B. As of the effective date, they are modifying that as of the relevant time, your claim would be disallowed under 502E1B, which is the section of the bankruptcy code that disallows contingent indemnity claims. Certain of our clients, including McKesson, have both fixed and contingent indemnification claims that they've asserted. And what I was told by Mr. Gott, and I'd like to confirm this, that the debtor does not intend to seek either disallowance of claims or subordination of claims pre-confirmation. And so that for the time being, the new class, which is class 9I of the plan, the no recovery opiate claim class, is an empty class, which may then get filled up should there be objections post confirmation and post effective date. If that's,
Your Honor,
if that's the case, then our concern over that section is resolved.
Yeah,
It is
Your Honor.
resolved.
Your Honor, I can confirm that the excuse me, the administration of the other opioid claims, which would include this basket, is a matter that's intended to be deferred until post confirmation, frankly, probably post effective date. And so, for the time being, in the absence of a ruling expressly disallowing or subordinating those claims, that is the outcome that would hold as of the confirmation date.
All right.
And
Let's
finally,
try to stick to the things that aren't resolved, because I only have an hour left and then I have another hearing. Okay. So,
Your Honor, I'll finish up by saying this: my group will over the next 2 months work with the debtors, hopefully to resolve the executory contract issues which remain unresolved that we dealt with we mentioned in our plan, our disclosure statement objection. The debtor can't operate without the distributors, and they just can't. Their plan will not be feasible. And so we'll see where we can get.
All right. Thank you, Mr. Garfinkel.
Thank you.
All right. What's next?
Your Honor, the next objection we would get to, so that would cover the next three unresolved objections. And the next one we would have is the Department of Justice filed at 2507.
All right. Who's speaking for the DOJ?
Good afternoon, Your Honor. It's Mary Schmergel on behalf of the United States.
Go ahead, Ms. Schmergel.
Thank you, Your Honor. So we did file our objection to the disclosure statement. I would say at this point, our objection as far as the adequate information has been resolved, in that the amended disclosure statement and plan that have been filed, and we understand that there will be another amended plan filed shortly after the disclosure statement hearing or sometime within the next day or two, does now disclose the treatment of the federal healthcare agency's claims. Unfortunately, the United States disputes and objects to the proposed treatment. It basically states that the United States will either have to reach a settlement or receive an unfair or discriminatory treatment under the plan while giving releases to the protected parties. As we detailed in our disclosure statement objection, we are not bound under federal law by any allocation that would be reached by the debtors and the other mediation parties. As the court is aware, we were a mediation party. And unfortunately, we would have to disagree with Mr. Gott's statement yesterday that we'll have to agree to disagree, respectfully disagree that the mediation was successful, because obviously the United States, that there has been no settlement reached with the United States. And that, by failing to reach a settlement with the United States, we may need to pursue our rights against the protected parties, which would include the debtors, possibly the reorganized debtors, as well as the various trusts and any entities receiving settlement monies from the trusts that are being proposed under the plans. In other words, what needs to be disclosed and what needs to be made clear, and we have asked the debtors to insert a footnote into the disclosure statement, which we understand that they have agreed to do. But the creditor groups need to understand that without a settlement, they may be receiving, it may be their share under the proposed trust may be misleading, in that it does not account for the fact that we may seek recoveries from these trusts post-confirmation under federal law. So that's why we thought this footnote was important, so that all the parties and creditors are aware that if there is no resolution with the United States, their shares may ultimately, or whatever they receive under the trust, may ultimately be reduced by the government's medical recovery claims. We also, Your Honor, would like to note, many of the parties and creditors in this case have mentioned or acknowledged that the proposed trusts that are being under the new amended plan mimic or are similar to or follow the same allocation scheme as the trust in the Purdue Pharma case. We would like it to be noted, in case for those who are not aware, the United States was not a mediation party in the Purdue Pharma case. There is no proposed trust in the Purdue Pharma case for the United States. It is widely known that the Department of Justice in the United States entered into several different types of settlements with the Purdue Pharma. We consider Purdue Pharma to be a vastly different case than the mallinckrodt case. For full disclosure, there is a settlement, a current settlement pending before Judge Strain and the DOJ that would resolve the federal healthcare agency claims, which are the claims that were at the subject of the mediation in this particular case. However, that settlement has yet to be approved by the DOJ or Judge Strain, and it is based on the very specific facts and circumstances of the Purdue case. It is not binding or has no precedential effect in this case. So we would caution any creditor or creditor group looking to the settlement in Purdue Pharma for any kind of guidance as to what might be an appropriate amount of the federal agency's claims in this particular case, particularly since mallinckrodt did produce and distributed significantly more opioids than Purdue Pharma. So again, we recognize that our objections to the proposed treatment is more of a plan confirmation issue, but we thought it was important to raise this issue before the judge and the court and the other creditors, because we do believe our plan objection could ultimately lead to a significant reallocation of the proposed settlement trusts. And again, we want that to be noted, and I'm sure Mr. Gott will confirm that the footnote that we've requested will be included in the disclosure statement.
Ms. Gott?
Yes, Your Honor, we are, my understanding is that there is a agreed upon language at this point that we will be including in the documents. And suffice to say, of course, the debtor's position on some of the legal and factual assertions that Ms. Schmergel just made, that we disagree with them. But my understanding is that the language is close, is at a resolution.
Ms. Schmergel, does that address your concern?
Yes, Your Honor.
Okay, thank you. Anything else? Ms. Schmergel? No, okay. Mr. Gott?
Your Honor, the next objection on the list was filed by Blake Kim, docket number 2509 and docket number 2531.
Good afternoon, Your Honor. My name is Blake Kim. I'm the CEO of Burlingame Investment Group, investment advisor to our clients that are invested in 4.75% notes guaranteed by mallinckrodt PLC, the parent and holding company of the debtors. Basically, Your Honor, we have 3 objections. The first of which is that the disclosure statement is opaque and very complex. The updated disclosure statement has made some improvements, but that's mostly for other classes. Or for our class 6, the improvement is small to none. According to the information provided, the recovery value of our class is somewhere between 0.8% to 34%. That is basically a huge range. It's all or nothing, sir. And as a fiduciary to our investors, we cannot make any intelligent vote on the plan. So we're asking that they narrow down what the recovery value for us would be. And also, our class is the only one with such a wide range of outcomes. Again, we are a financial debt creditors.
Well, on that issue, Mr. Kim, it's difficult for the debtors to be able to give you a precise amount of recovery here because there are huge unliquidated claims against the company.
Yes, sir.
That remain outstanding that haven't been resolved yet. So it's a lot of it is going to depend on your client's recoveries. A lot of it's going to depend on what happens to those other contingent unliquidated claims that are out there. So that's why there's a wide swing.
Our biggest issue with that is that most of the claims are borne at the subsidiary level. We're a holding company creditors. Anyway, that leads to our objection number 2, which is kind of tied. Basically, our class 6 is designated as like a black hole. The debtors have basically stuffed 4.75 note holders with the rest of unsecured claimants, the holders of claims that are not resolved. And most of these claims, again, were perpetrated at the subsidiary level, such as Actar jail claims that are non-governmental and asbestos. You know, the absolute priority rule dictates that similarly classed creditors be treated equally. But the debtor's disclosure statement clearly singles out a recovery range that is hard to analyze and very well brings zero recovery for us, a financial creditor. This is complete violation of one unsecured creditor class to another, sir. And our objection number 3, sir, is we feel that there should be a substantive consolidation. The debtors have been reporting their financial numbers for many years on a consolidated basis. As a result, as a note holder, we have no intelligent way of deciphering what our security value should be. Furthermore, the senior management and the board of directors have been shared by the subsidiaries and the holding company. For all these reasons, we feel that in addition to class 6 being the most of the claims in the class 6 being perpetrated at the subsidiary level, we believe that the disclosure statement should be revised and produced at a substantive consolidation level, sir. And I mean, I refer the objection 4 to confirmation, but it's basically valuation. We feel that completely lacks credibility.
All right, Mr. Gott.
Your Honor, I think the arguments Mr. Kim is raising all fundamentally go to the question of whether the proposed treatment for class 6 creditors is fair and appropriate and meets the confirmation standards. We think those questions are appropriately deferred until the confirmation hearing. We of course believe, as we stated in our disclosure statement and have added supplemental disclosures to address similar objections, we of course believe that the plan and the rationale and analysis underlying that plan are all fully compliant with the bankruptcy code, and that we will carry our burden at the confirmation hearing. But we think these issues are for another day.
All right. I agree. I think, Mr. Kim, the language that they posed for your objection number 1, I think that resolves the issue with regard to the disclosure statement itself. Your other objections all go to plan confirmation, which your objections will be preserved until we get to the confirmation hearing, which will be in September, and you will have the right at that time to raise these objections against the confirmation of the debtor's plan.
Thank you, Your Honor.
Okay, thank you.
Next, Your Honor, we do have on the list, so we resolved the objections of the future claims representative. We do have on the list the opioid claimants committee, who will be among those looking to make statements by the end of the hearing. And as we noted in the chart, I think there are also there may also be scheduling and/or discovery protocol issues that are still outstanding if they haven't been resolved during the course of the last couple hours. So those are not for right this moment. Come to those soon. We have next on the list is the Canadian Elevator Industry Pension Trust Fund. I think it was Mr. Joyce who addressed this point earlier, and I'm not sure if there was. I think there was nothing else to address from his objection, but I will pause to allow for anyone to correct me on that front.
Your Honor, Michael Joyce, Your Honor, we just reserve our objections for confirmation.
All right, thank you.
And so the next unresolved objection would be that filed by the Ad Hoc Consortium of Equity Holders of mallinckrodt PLC at docket number 2616. Your Honor, this objection was filed substantially after the deadline to file objections, but we're happy to address them nonetheless. We were able to resolve the objection regarding disclosures around the releases, but we believe the remainder of the objections all go to squarely to confirmation and should be reserved for that time.
All right. So I'm going to speak for the Ad Hoc Consortium of Equity Holders.
Yes, Your Honor. Good afternoon. Stephen Smith from Herrick Feinstein on behalf of the Ad Hoc Consortium of Equity Holders.
Go ahead, Mr. Smith.
Thank you, Your Honor. I'm going to be even briefer than I planned to be, given the arguments already raised and Your Honor's ruling, but I do have several points I'd like to make. The consortium organized recently in reaction to a plan which, if confirmed, will wipe out equity completely and do so throughout the improper de facto substantive consolidation of legally separate and distinct debtor entities. Many of the objections we raised in our papers, Your Honor, regarding the adequacy of disclosure have already been resolved or discussed by Mr. Feldman on behalf of Humana Tester, Mr. Meza on behalf of the SEC, Mr. Etkin on behalf of Marietta and others. And we heard Your Honor's rulings on those issues, and so we'll simply preserve our objection on these issues for the confirmation hearing. But we raised two arguments in our papers, Your Honor, that the plan is patently unconfirmable, sufficient, we think, to prevent the approval of the DS, the disclosure statement. The first one, Your Honor, did discuss earlier, and that relates to the non-consensual releases and the opt-out mechanics. And so we'll simply preserve our objection on those issues as well for confirmation. But we think, and we submit respectfully, that the plan, as proposed, improperly substantively consolidates the debtors for purposes of funding plan obligations. And if corporate formalities are respected, Your Honor, it's possible that there are debtors on the specialty brand side of the business that may be solvent, and where the value would travel up the chain to the public parent, leaving a potential recovery for equity. And as we said in our papers, Your Honor, the debtors have consistently taken the position that they have obeyed all corporate formalities. In response to that argument, the debtors are now saying and arguing that the pooling of the assets under the plan as part of a Rule 9019 settlement in order to achieve global peace, but that's essentially an end run around the normal stringent substantive consolidation analysis that is required by the Third Circuit in Ray Owens Corning, 419 F3rd 195, and by this court, Your Honor, in Ray HH liquidation, 590 BR 211. And I can tell Your Honor that this issue of trying to squeeze substantive consolidation under the 9019 umbrella came before Judge Drain in the Chapter 11 cases of Loral, Space, and Communications in the Southern District of New York, case number 03-41710, at the hearing to approve the disclosure statement. And there, in that case, Judge Drain was not inclined to approve the disclosure statement and sent the parties back to the drawing board. So for this reason, Your Honor, we respectfully submit that the plan is patently unconfirmable, and as a result, the disclosure statement should be denied at this point. With that, I'll rest on my papers and yield the podium. Thank you.
Thank you. Mr. Gott?
Your Honor, we think the ad hoc consortium is fundamentally misunderstanding the plan. The plan is not proposing a substantive consolidation other than in one very narrow respect, which is that distributions to Class 6 creditors will be done on a consolidated basis. And for all other purposes, everyone's entitlements and everyone's in satisfaction of all the requirements under the bankruptcy code will be undertaken and will be satisfied at the confirmation hearing on a debtor by debtor basis. To the substantive points articulated by counsel, we will show at confirmation that the distributions that are provided for under the plan are consistent with those entitlements when you look at it on a debtor by debtor basis. And as Your Honor has already ruled in these cases, that equity holders are in fact out of the money. So we believe that this objection should be overruled.
I agree. I think the objection, if there is an objection here, given that I've already ruled that the debtors are hopelessly insolvent, that the equity claimant's objections can be heard at confirmation, and I'll overrule the objection now. And Mr. Smith, you can raise those objections at confirmation if you choose.
Thank you, Judge.
And Your Honor, the last objection on our chart filed by the public schools, we've been able to resolve that. So that would bring us to the end of the disclosure statement and solicitation procedures related objections. And at this point, we would, I think we'd be pivoting toward the scheduling and discovery protocols motion, unless Your Honor has any questions. And I think at the end of the hearing, we'll wrap up with a discussion of our exact steps forward from here.
All right. Are we going to discuss are we going to allow the UCC to make its statement on the record? I think the OCC wanted to make one as well.
Yeah, if Mr. Price has been able to join, we could do that now, or we could save that for the end of the hearing if he has not been able to join as of yet.
Mr. Price, are you with us, or are you still with Judge Drain up in New York? It's like he must still be with Judge Drain. So we'll skip that for now and move on to the next.
Well, on behalf of the NAS ad hoc, the Judge Drain is issuing his ruling right now. So we anticipate it will be over shortly. Thank you.
Thank you.
Your Honor, this is David Giattino, Stevenson Lee. I'm here appearing for the public school district creditors. Our clients wanted us to read something into the record, basically along the lines of that we're reserving our right to re-raise the objections in response to confirmation of the plan, and that our withdrawal of current objection isn't a waiver of our right to raise those objections.
All right, understood. Thank you.
Thank you, Your Honor.
All right. And with that, Your Honor, I will turn the podium over to Ms. Yaramali.
Okay, Ms. Yaramali.
Good afternoon, Your Honor. Anu Yaramali of Latham & Watkins on behalf of the debtors. Your Honor, now that we have a path to approval of the disclosure statement and for the debtors to commence soliciting the plan, we need to set the course of how we get from today to the confirmation hearing. As the panoply of confirmation-related objections has shown over the last 2 days, this will likely be a highly litigious confirmation process. Not every case has a confirmation, discovery, and litigation schedule, but a case like this calls out for one to create, from the outset, a manageable process to approach the confirmation issues in an organized manner and with the least number of fire drills before the court. Ultimately, the protocols are intended to provide reasonable default ground rules for an orderly process. They do not prevent any parties from coming back to the court to address specific discovery or scheduling issues as they arise. This alone should be the basis to overrule any objections. No one believes the schedule is perfect, but it is the debtor's view that we need to set this timetable and begin moving forward with discovery and hopefully in parallel continue negotiations to address plan issues. Your Honor noted earlier in the hearing that parties can proceed with mediation, negotiations, and other litigation while the confirmation process proceeds, particularly given the mounting costs of this case. We appreciate that the court and chambers have been extremely flexible with the pace and schedule of these cases. This timetable and set of protocols seeks to establish a framework for the benefit of everyone. The dates and deadlines may be viewed as tight, but that tends to push parties to make compromises or to narrow issues. As Mr. Gott has tirelessly poured through over the last 2 days, we have tried to work on disclosure, schedule, and discovery protocols with each objecting party. The objections to the schedule and the protocols generally fall into a few categories, namely that the schedule was too tight, that there is insufficient information to begin the confirmation process, and that there are a few disputes over the details of document and written discovery and deposition protocols. We've engaged in extensive negotiations with both committees to reach compromises that we believe address all of the objecting parties' concerns. The committee's input, particularly on this schedule, was informative and led to consensus on the timetable amongst the debtors, the RSA parties, and the committees. Some of the key changes that we made were extending the solicitation directed deadline to July 15th at 4 p.m. We also agreed to file the trust distribution procedures on the earlier of July 21st, 2021, or within 30 days from entry of the disclosure statement order. Many objectors felt that this information is needed for voting purposes, and we provided a mechanism for that to occur. These will now be filed 44 days before the September 3rd voting deadline, which we also extended from its original date. We increased the time by when we will file the plan supplements from 7 days to 28 days before the voting deadline. We also agreed with the 1L and 2L note holders, which may have certain claims that will be subject to litigation at confirmation, on a schedule for when claims objections would be filed. We finally agreed to commence the confirmation hearing on September 21st, 2021, which I believe works with the court's calendar. I think the way to proceed with this particular motion is to deal with the schedule first. There are a few open points on the discovery protocols that the litigation experts are trying to work through as we speak. And if they are not resolved in the next, by the time I get through the scheduling issues, then we can take those up after the schedule. But as you can see from this hearing, there are numerous confirmation issues on which new parties will be seeking discovery. We believe that the schedule for discovery, including deadlines for the parties to serve document requests, and the discovery protocols and limits we are seeking are absolutely necessary to bring order to what could become significant chaos. It is beneficial to all parties, including those objecting, to know what the process will be, how written discovery will work, how depositions will be scheduled and conducted. So with respect to the schedule itself, Your Honor, we have resolved the timeline and the schedule with the following parties: the OCC, the UCC, the Department of Justice, the ad hoc 1L note holder group, and Deerfield. West Virginia withdrew its objection last night, and I understand that the city of Marietta is not pressing its objection. I believe that leaves 4 potential parties that have objections to the schedule, which we should take in turn. The first is Mr. Darrell Edelman, who had spoken previously.
Mr. Edelman? Mr. Edelman, do you wish to be heard on the schedule?
Sorry, as I said, I'm not very computer literate. No, that's fine on the schedule. Thanks.
All right, thank you.
The next is the ad hoc consortium of equity holders.
Okay.
Good afternoon, Your Honor. Christopher Cardy of Herrick Feinstein for the ad hoc consortium of equity holders. I'm just going to speak briefly to the schedule, as the debtors' revised schedule did address many of the issues we raised in our objection. The objection we continue to press and the observation to make is just about the compressed time still left in the schedule, which while the debtors did push back the confirmation hearing about 3.5 weeks from their original proposal, it seems that most of that time is allocated to extending the substantial completion deadline for the debtors to July 30th. And that is going to leave the parties virtually no time to review the documents the debtors produce, prepare for depositions, and take depositions in, I think, what's just a 2-week period from the end of the substantial completion deadline to the end of fact discovery. And I think it's worth noting that in the revised schedule, the debtors submitted, I believe yesterday, that they have not yet committed to the substantial completion of deadline of July 30th. They note that because that they seek the right to modify that deadline because they do not know the scope of planned discovery that will be served on them. And I think it's fair to say, after the last 2 days of hearing, there are a number of issues that will be raised for confirmation. And as debtors counsel noted, this is likely to be a highly litigious process. It's our position that by setting a schedule now, we're really putting the cart before the horse, that it may be more efficient for the debtors to take in planned discovery, determine what that will entail on their end, when they will be able to produce documents, and for the parties to decide on the rest of the dates just based on an understanding of the debtor's schedule for producing documents. But at the very least, I think we're going to just have to make clear that we're reserving rights to come back and seek modifications to the schedule depending on when documents are produced in the case.
Well, there's always a right to come back if the schedule is not working. So that's not an issue. So at this point, in litigation, as a former litigator, you usually have a trial date and you work back from there. Here we have a confirmation date and we're going to work back from there. So we're working within the time frame that we have. So it can be done. It's been done many times before. So I think in terms of timing, at least at this point, sitting here, it looks like that's something that can be accomplished. But as I said, everyone certainly has the right to come back later and say, it's not working. And we can revisit it. So this isn't written in stone. It's just written on paper at this point. So.
Okay. Thank you, Your Honor.
Thank you, Your Honor. The next objection is that of the distributors with respect to the schedule.
Your Honor,
Okay.
Jeff Garfinkel on behalf of McKesson and certain of its corporate affiliates. The only concern that we have is, and we put this in our objection, is the June 23rd deadline to do written discovery. That is awfully quick to this process. We think it should be 1 week later, such that it would be June 30, and all the discovery response dates on document productions would then flow back by 1 week to require this document production request to go out a week from today, when we're still evaluating a number of these influx provisions, is we think too short. That's the only criticism that we have to the procedures, Your Honor.
Your Molly?
Your Honor, To echo what Your Honor just said, we took a start time for the confirmation hearing and a starting date and worked backwards. I believe that, discovery requests can be served by the 23rd. If there is a need to supplement them because something changes, we can pivot real time. But the goal for today is to set a process and to have it start moving. I think we are otherwise trying to extend dates and negotiate dates in a bit of a vacuum. And I think we need to do what works for the schedule that we've set forth, which numerous parties have agreed to. And if we need to make a change, parties' rights are reserved to come back to court.
Yeah, I agree. I think you have a week. I'm assuming you've already started working on your discovery request since this plan has been on file for quite some time. So I'd be surprised if you haven't already begun drafting your discovery request. I'm sure there's a number of parties who've already issued their discovery requests. So I think the 23rd at this point is workable. If it turns out not to be, parties are free to come back and ask for additional time.
Thank you, Your Honor. The remaining objection to the schedule is that of a testor in Humana, which I think is going to bleed into some of the nitty gritty on the discovery protocols, which the litigation experts are best suited to handle, because they've been talking about it as we speak in this hearing. But just very quickly, I wanted to address Your Honor's question about how to handle the confirmation hearing and whether it should be in person or virtual. When we spoke to Your Honor's chambers, and we understand that September 20th to 22nd are available, and then there may be some additional time the following week if we require additional days. What we have proposed in the schedule is that September 20th would be a pretrial conference and that the confirmation hearing would begin on September 21st. We would use September 22nd, and then if Your Honor has availability the remainder of the week, we could do that, or we would reconvene that following Monday. With respect to whether we should decide today whether it should be in person or virtual, the debtors believe that we should have it be a virtual hearing today, but revisit in August when we have a better sense of what the protocols are, what the building capacity will be, and more importantly, what remains contested versus whether there have been resolutions so that we can better assess how many people will need to travel to Delaware to attend the hearing in person and what the numbers are going to look like as to who has to be in the courtroom. I think trying to make that decision today is a bit premature.
I agree. I think I just threw it out there as a possibility, but yes, we still have time to wait to consider whether it's going to be practical given the number of people involved in this case. Even without COVID protocols, given the number of people on this Zoom call, if everybody wanted to attend in person, we would have to use a overflow room because not everybody would fit in my courtroom. So we'll play that by ear and we'll revisit it sometime in August.
Thank you, Your Honor. I will now.
Do we have, let me ask you a question, Mr. O'Malley. Do we have built into this discovery protocol periodic status conferences, just so I can have those on my calendar in case issues do arise? We can use those, or do we have omnibus dates still on the calendar that we can use?
Your Honor, we do have 2 omnibus hearing dates per month that are separate and apart from this schedule. We can, if useful, build into this calendar those particular omnibus dates to have status updates provided at the time. Or we can set different dates, whichever your preference is.
Let's use those and include a status update. And if parties have issues about discovery or any other things of that kind, we can deal with those at those omnibus hearings.
That makes sense to the debtors, Your Honor.
Thank you.
So the final objectors are Tester and Humana with respect to discovery and the schedule.
Are we prepared to go forward with that, or are we still discussing issues?
Your Honor, can you hear me? Benjamin McCallan from Wilkie Farr and Gallagher on behalf of the Actar insurance claimants.
Go ahead, Mr. McCallan.
The short answer is, Your Honor, I don't know. We've actually been having email correspondence while this hearing has been going on. So I'm frankly not sure about the scope of the disagreement, if any. I'm happy to address what I believe to be the open issue, and debtors counsel can correct me if that is in fact the only open issue.
Well, let's go ahead and why don't we, I do need to take a little bit of time before my next hearing because it is a live hearing. It's actually a hybrid, some live and some people will be online, and we're using a different system for conducting those hearings when they are live. So I need to make sure the IT folks have got this all set up and ready to go for 3 o'clock. I expect that hearing will not take more than an hour. So why don't we recess now? We'll reconvene at 4 and we'll wrap up the rest of the issues at that time. That'll also give those who are attending the Purdue hearing an opportunity to breathe for a few minutes before jumping on this call.
We appreciate that, Your Honor. Thank you.
All right, so we will stand in recess until 4 o'clock. Thank you.